knows up, because in the answering affidavit, he talks about the circumstances that led to the deaths of your Kopolotas and everyone else. Now, basically, he accepts that he knew how they died. Now, remember, for management, the requirement is knowledge. Now, if we accept that Booysens knew, do you still maintain that it was not proper for Booysens to be charged for racketeering for the purpose in contravention of Section 2(1)(f)?
I don't see how paragraph 2 assists with that he had knowledge, because he qualifies it. I might have had personal knowledge, but alternatively, any information relating to that might have been obtained from files and documents under or in the control of the South African Police Service. I can't see how that paragraph 2 can lead you to that conclusion that he had knowledge of that the Cato Manor unit were unlawfully killing people.
So do you still maintain that they were not, the Major General Booysens, there was no evidence that he knew?
That is correct. And if I'm allowed to, I can qualify why I say that when it comes to knowledge.
Just briefly, ma'am.
And my...
Advocate Riley, you wanted to explain, to qualify. Can you just qualify that briefly?
That the evidence in the dockets doesn't show that he had knowledge that the Cato Manor unit was unlawfully killing people for rewards.
Can I follow up on your question, Advocate Mtsweni? Advocate Riley, do you accept that GSM 7 is an affidavit prepared under oath?
That is correct, ma'am.
And do you further accept that the deponent says the facts stated herein are within my personal knowledge, and he says that under oath to a court?
But it qualifies it. Alternatively, it could have been obtained also from other sources.
Please don't leave me behind. I'm still coming.
Okay.
Do you accept
Sorry about that.
Do you accept that he says the facts stated herein are within my personal knowledge and belief?
That is correct. I accept that's what he says in paragraph 2.
And then he says, alternatively, alternatively, I may have obtained them from the files and documents under or in the control of the SAPS.
That is correct.
And he further says, well, unless if the contrary is proven, but I accept that everything is within my personal knowledge.
That is what he says.
And do you accept that this is a standard way of saying to the court, I am not bringing hearsay evidence. I'm bringing evidence that is within my personal knowledge. Where it is not within my personal knowledge, someone might file or may file a confirmatory affidavit.
That is correct.
So do you accept that this is what this paragraph means?
I accept that what it means.
Thank
it's
you.
Either information to his personal knowledge or alternatively that you have obtained from the South African Police Service.
Thank you.
Now, Advocate Riley, does it matter for the purposes of Section 2(1)(e) as to how one acquires the knowledge?
2(1)(e) or 2(1)(f)?
2(1)(f), I beg of you.
We have to prove how did he acquire the knowledge.
Yes. But the question is, that does it matter?
Doesn't matter, but we still have to prove how we acquired the knowledge.
Advocate Riley, I'm going to really beg you to answer Advocate Mtsweni's questions. If the question starts with, does it matter? Then it means the question should be, yes, it does, or no, it doesn't. Thank you.
Thank you, ma'am.
Now, just on your answer, when you say we have to prove, now, do you still have to prove when Major General Boysen says so himself that I know, when he makes an admission? He admits himself that he knows. He said so on his own words. I know.
And I still don't agree with you, Advocate Mtsweni, that paragraph 2 speaks only of personal knowledge. It's qualified by the fact that he could have obtained the knowledge from files, documents in the control of the South African Police Service.
Okay.
If it simply said there, personal knowledge, then I would have conceded to that.
Okay. Can I just make the following analogy? Sorry.
Advocate Mtsweni, I think you have been dealing with the issue of management.
Yes.
For a long time. This could be a matter for argument.
Yes, thank you, Madam
I'm
Chair.
just getting worried that we are not making any progress, and we are still going to take a long time, I suppose.
Yes.
I think the witness has answered. Maybe you can consider moving forward.
Thank you, Madam Chair. Now,
may I just ask the witness, Advocate Riley?
Yes, ma'am.
It seems to me you are very angry as you
No, I'm
answer
not,
the questions. If you can get composed, if you need a short break so that you can take a deep breath, let us know. We will allow you a chance to pause and reflect and come back. Against the background that I postulated to you that we are here on a fact-finding process. We are not a court. We seek you to assist us, and we really plead that you assist us. Do you understand?
Understand that, ma'am.
Do you understand our approach?
That is correct, yes.
You have read the terms of reference, and you know why we are here. We seek your
correct,
assistance to the extent you can. If you cannot, you can say so. But don't be agitated, and I can see that you are very unhappy as you answer our questions. Do you need a break?
Yes, ma'am, please, thank you. I would appreciate it.
Yes, please take a deep breath and stay composed. We'll pause for 5 minutes to allow you a chance to compose yourself, and we will come back in at about 1:15. We are still under oath, madam. We're taking this short break to give you a chance to compose yourself. We'll pause for a few minutes, Advocate Mtsweni, and resume at 1:15. We will take a lunch break at 1:30. And I do so because I can see that Advocate Riley is just unhappy.
Madam Chair, if I might just say to Advocate Riley. Madam Advocate Riley, I'm not seeking to persecute you by asking you these questions. All we're seeking to do is to just ascertain and get clarity on the conclusions of the panel's report and test those conclusions. I'm not seeking to persecute you or prosecute you, ma'am.
We've made an observation as we are looking at the witness and the way she answers questions, and I think it is fair to her as she agrees that she needs to pause and compose herself. May we pause for a few minutes and give her an opportunity to compose herself. Thank you. And pause. Good afternoon again, Advocate Riley. Advocate Riley.
Ma'am, I'm here.
Oh, good afternoon.
Good afternoon.
You feeling better?
Yes, ma'am.
Yes, thank you. You can take a glass of water, just put it in front of you, and take your sip as we proceed. You continue to be under oath, madam.
Yes, ma'am.
Thank you. You may proceed, David Mtsweni, until 2 o'clock. We will take a lunch break at 2 o'clock, and hopefully you would have made progress by the time we pause.
I hope so, Madam Chair. In fact, I'm going to try now.
Remember, we have to work until late.
Yes, no.
But that does not necessarily mean that you must move slowly. Please, let's make progress.
Yes. Now, Advocate Riley, we've covered insofar as Major General Poison is concerned. We now move on to the other members of the Cato Manor who were charged together with Poisons for management. That is Olivier, Eva, Lockham, and Van Tonder.
That is correct.
And you say that the prosecution memo is quiet or is silent as to what role they played in their, what is it that they did in their managerial roles. And on those basis, you then say that the fact that they were commanders or held senior positions within the unit is not of its own sufficient to prove that they were managers.
That is correct, yes.
Yes. And you say, in fact, this is one of the issues that I didn't cover under Major General Poisons. You then say, further, if they were managers and participated in and managed the enterprise, then one would have expected them to be charged for the underlying predicate offenses.
That is correct, yes.
Now, if I might ask, is it a requirement or necessary for one, when charged in terms of Section 21F, to also be charged for the with the predicate offenses?
Can you just refer me to that part? Which paragraph is that?
Paragraph 89 of your statement.
You can read paragraph 89 in conjunction with paragraph 88.
Maybe I can just explain my submission in 89. I said, and the panel concluded that if you based it on knowledge, that they were aware what the Cato Managed Unit did in terms of a pattern of racketeering activity, in terms of the underlying predicate offenses, that they were involved in several crimes in the sense of that they went out to kill people, not in self-defense, but for the purpose of rewards. That knowledge would have then be, one would have expected that as managers, they would have been charged for all the predicate offenses, because that's the premise or the basis, that they had knowledge about each and every murder or killing of innocent people.
Yes. Now the question then on those bases, I'm saying that for the purposes of contravention of 21F, is it a requirement that the person charged for playing a managerial role also be charged for the underlying predicate offences?
No, it's not necessary, but I said I would have expected if you had knowledge of 28 murders and you did absolutely nothing about it, even negligently, one would have expected the whole group to be charged for all the murders because they had knowledge that these people were killing people unlawfully.
Okay.
That's the point.
And then you again repeat at paragraph 90 that even the evidence by Londlo and Matonsi that Mostert was present when there were payments made by the Stenga Talks Association, it would not be sufficient because they were not to say that you say that you said Mostert was not charged for contravention of section 21F.
The reason we looked at those statements and we also looked at the other predicate offences is that master tends to play a very prominent role. So our understanding was that if you look at how they structured who are the people that participated in the enterprise and who are the people that are the managers of the enterprise. We argued that it doesn't matter what your title or status, you must exert some degree of control over the operations of the enterprise. And we found that there was evidence to that effect. Now, if you simply excluded him on the basis of his rank, we felt that was, they could have charged him also in terms of 21F.
Now, the question that I have follow up on that is, does the fact that a person who ought to have been charged was not charged, does that render the charging of those who have been charged wrongful?
No, it doesn't make it wrongful.
Yes. So the question is, does the fact that Mostert was not charged for contravention of 21F, does it have any role in the others who were charged in the decision to charge others for management?
No.
Yeah. Okay.
Sorry, the follow-up question would be, you were asked to analyze and where you find shortcomings and you identify them. For example, here you identify that Mostert should have been charged in terms of 21F. Wasn't it prudent that in your conclusion and recommendations you assist, because you are all members of the NPA, you assist the prosecution or you assist the NDPP with taking this matter forward by making recommendations that, for example, Mostert should have been charged in terms of 21F, which to a certain extent may have strengthened the NPA's case against the Katomena, instead of pursuing just one line of analysis that is finding fault with those that were working on this, and at the end coming to the conclusion that the authorizations by Advocate Abrahams were unlawful and therefore should be set aside. Thank you. What is your comment on that?
We did say that he should, if the prosecution was proceeding, it should have been charged for 21F. We do make it in our, we make that submission in our report. And we explain why we say he should have been charged for 21F.
Now, the reason you say that you should have been charged in 21F, would I be correct to say it's because you accepted that there was strong evidence, given what you could pick up from the dockets the prominent role that he played in these activities?
Based on the predicate offences, as well as if you had to proceed on the hearsay evidence, in terms of what they said, that he attended a meeting, for example, with Major General Boyson, and that he received a bag of money.
Yes. Now, when you read the dockets, you also find that in most of the crime scenes, after the person would have been killed, Captain Eva would take over control of the scenes and manage the scenes. And it was on those bases, according to Advocate Mayema, that he was charged for contravention of Section 21F. Now, if you say that the role that Mostert played was significant, would you say that Eva's role was also significant?
In the context of, and I'm trying to understand.
Crime scene management. After most of the suspects would have been killed, Captain Eva would come in and manage the scenes, and the evidence that we'll look at shortly would be that he would plant the firearms that were allegedly used by the deceased in so-called shooting the police. Now, if that evidence is proven to be correct, that Captain Eva played that role of doctoring the scene, would you accept that then, therefore, it was correct for him to be charged for management because he played a critical role?
That's the evidence. Yes, I would agree. He played a critical role in.
Yes.
If the evidence is that he planted firearms and that he cleaned up the crime scene, if that's the evidence, yes.
Now, let us look at that evidence. In the document that you gave us earlier, where you were asked to analyze where you analyzed the ballistics, do you recall that?
That is correct, yes.
And the first case, the sixth case that you looked at, and I'm just want to zoom in on what Captain Mangena said. Remember, you wanted to deal with Captain Mangena's evidence.
That is correct.
Yes. Now, this is that time, ma'am, that I'm going to ask you to deal with it. Now, if you look at case number 6, Durban Central, amongst the dockets that you analyzed was the report by Christian Mangena. Is that correct?
Let me just with my notes. I just want to compare it with my notes.
You just have to look at case number 6 on the list you provided this morning. You list A, B, C. Number C, an affidavit by Christian Mangena.
That is correct, yes.
Yes. Now,
Where do I find that?
on the second page of the document that we gave this morning, the case number 6.
Durban Central.
Durban Central, yes. Now, I'm just going to ask Advocate Lekgetho to go to the statement by Colonel Mangena, who at the time was a captain, and the annexures to his statement or his reports, and go to page 2A-68. Are you there, ma'am? Is Advocate Lekgetho helping you?
Just looking for it, yes.
You're referring us to that document as well?
Yes, I'm going to ask to go to 2A-68. That is his report in the Durban Central case.
Where do we find that in these bundles of documents?
It's in annexed to Captain Mangena's statement.
Yes, but please refer us to the volumes, Counsel. You have prepared for leading evidence, and you have to assist us.
I'm not sure of the volume number, but it's 2A-68, page 2A-68.
Yes, thank you.
Did Advocate Lekgetho find the document?
Not yet.
Advocate Lekgetho, you can look at 2A, Colonel Mangena Report, Volume 1 of 2. Volume 1 of 2, 2A, Colonel Mangena Report, Volume 2, 1 of 2. The page referred to is 2A68. It is a section 212 statement by Christian Mangena. Are you finding it?
Yes, ma'am. I'm looking at it now. I'm just trying to go to the first page.
Yes. It's in relation to Durban Central case.
Yes, ma'am.
We can tell him who the deceased was in that case.
Yes. Now, Advocate Riley, this is Captain Mangena's statement. Colonel Mangena, in fact, currently, and at the time was a captain. This is his ballistic report in the Durban Central case, which related to the death of Mr. Bongam Kize. Do you remember Bongam Kize was referred to in Zondlo's statement as the person the Cato Mena struggled to kill because he was highly connected?
That is correct, yes.
Yes. Now, if you recall, and you said this report is amongst the documents that you considered when you prepared your report.
That is correct.
Yes. Now, if you recall, the facts in this matter is that the members of the Cato Mena unit, together with members of the NIU, had tried to flag Mr. Mkize, who was driving a black Lexus, and then Mr. Mkize refused and then started firing at them, and then they retaliated. Do you recall that?
That is correct. That is correct, yes.
I just want to take you to, I'm not going to go through the entire report, but I want to take you to the conclusions by Captain Mangena on page 2A-89 under paragraph 13.
Paragraph 13.
It's on page 2A-89.
Yes, I'm there. Paragraph 13, yes.
At paragraph 13, it says, after observation of the crime scene photos, post-mortem reports, ballistic reports, and statement by officials, I could reach the following conclusions, right? He says at paragraph 13.4, The smaller shrapnel laceration injuries sustained by the deceased on the right arm and right side of the face were probably caused by glass particles and bullet fragments created by high velocity bullet impact on the glass. This gives the impression that the driver's side window was shattered by bullets fired into the vehicle. The shrapnel laceration injuries sustained on the right arm give an impression that the deceased's arm was stretched forward, possibly holding the steering wheel. Do you see that?
It is correct.
And it says the person who fired the shots with low velocity firearms were positioned on the right side towards the back. And then he says at 13.5, the position of the cartridges of cartridge cases and glass particles at the crime scene gives the impression that the vehicle was stationary during the incident. And then 13.6, there was no sign that shots were fired from inside the vehicle. Do you see that?
That is correct.
So basically, what Captain Mangena says is that Mr. Mkhize did not, and was not, when he was shot, was not firing at the police. In fact, he was holding his steering wheel with his right hand. Do you see that?
I see that, yes.
And if you look at this evidence, just asking, I'm talking on the basis that you found in your report that there was no evidence of a pattern of racketeering. Now, if one was to accept what Captain Mangena says, would you agree that then that would mean that Mr. Mkhize was killed? He was not shot in self-defense.
If you base it on Captain Mangena's report, yes.
Yes. And then we then go on to the next report, which you considered. That would be the Malmoth case. No, let's start with, sorry, Madam Chair. We go to the Eskawin. That is the case of, I think it's, I forgot the name, KwaZulu-Natal, am I correct? It's a case relating to the death of KwaZulu-Natal. It's on the 28-101.
Just trying to find it.
Have you found it?
Yes, sir. Yes.
In fact, on this case, you, in your report, it accepted that that the KwaZulu-Natal was an innocent person, because him and Kanyisile Biela, there was a chapter that you say killing of innocent people. Do you recall that?
That is correct, yes.
And in fact, in this case, amongst the recommendations you suggested was that, in fact, Parayachi must be prosecuted.
That is correct, yes.
So would I be correct that you accepted that the version that he was killed in self-defense was not probable?
Based on the evidence in the docket, yes, in that specific docket.
And you know that evidence, there were attempts by his colleagues to corroborate that version, and despite that, you still found that it was not probable.
Based on the evidence in the docket, yes.
Yes. And if someone goes on and says, well, my colleague shot this person in self-defense, very well knowing that that was not the case, and the person is charged with management, then you can accept then that the person knew that the colleague had embarked on a pattern of racketeering activity over and above other incidents.
In that specific incident, yes.
And if the evidence shows then that Eva, Lockham, and those others knew that what Pareachi did in killing Kwazi, he was not acting in self-defense, but had killed him for no reason, that might then mean that they knew that their colleague had embarked on a pattern of or had conducted a racketeering activity.
If the evidence shows that they knew, yes.
But you found that their version that their colleague had shot this young man in self-defense was not probable. Hence, you said he must be charged.
That is correct on the evidence in this docket.
Yes. So, let me just go take you through the last report by Mangena. That would be the Pine Town on 28-227.
Sorry, Advocate, for the sake of the record, we have two Esikawin on this list. We have, on this list that was submitted in the morning. We have 14 and 16. Maybe if you can just clarify, which Esikawin were you referring to? Because both have Captain Mangena's report.
The Kwazin Ndlovu that we were looking at is number 3. Three of 4 of 2010.
Or 304. 304, that would be number 14.
Yes.
Okay.
In fact, madam, I think the most one that I just want us to, let's look at the Melmoth one at 1812. Sorry to send the panel and my colleagues up to and fro. It's at 28181.
You're referring to the Esekaweni Met case number?
No, the Melmoth, madam.
Melmoth.
That is another case where there was a death of an innocent person or a person who was not a suspect. Kanyisani Biela.
Can direct Advocate Riley, that report, that statement, the affidavit is at 2A 181 of volume 2 of 2. Volume 2 of 2. 2A Colonel Mangena's report, volume 2 of 2. At 2A 181.
That is correct. I got it now.
You got it, thank you. Proceed, Counsel.
Now, I want us to go to the conclusions again under paragraph 15, which you starting from page In fact, at 28208.
Paragraph 15 starts at 201.
Yep.
Where do we find the conclusion? There we find findings.
Yes, but I'm focused on paragraph 15 on page 208. The last.
208.
Yes.
Which paragraph?
15.8.
15.8. Do you see subparagraph 15.8 at 2A-208, Counsel, Advocate Riley?
That is correct, yes, ma'am.
Proceed, Counsel.
Yes, ma'am. If you recall, in this case, it was a death of Mr. Biela. I would call him Biela Senior, and his nephew Kanyisani Biela, and both of whom were shot at different locations, but within the same home state. The other one was shot naked on top of rocks, and the other one was shot in the Rondavel.
That is correct, yes.
I just want us to just zoom on the one that was shot in the Rondavel, Kanyisani Biela, whom we know that was not a suspect.
That is correct, yes.
Yes. Now, in that case, what we know as well is that according to the statements, Kanyisani, the police were there looking for his uncle, and then the next thing he started shooting them through the window, and then that's when they then started shooting back in self-defense. That is what they say in the statements. Do you recall that?
That is correct, yes.
Yes, but now this is what Captain Mangena says in his statement to show that apparently that version was not correct because he could not have had a gun at that time. He then says at paragraph 15.8, I also observed the position of the firearm. The firearm is positioned on top of blood. Looking at the condition of the firearm, the condition of hands, the deceased and the movement of the deceased since started bleeding, I would expect the hand grips of the pistol to be smeared with blood. Do you see that?
That is correct, yes.
And if one was to look at if you just go back at least 3 pages at 205, 28-205. Are you there?
That is correct, yes.
And if you look at the gun that is lying next to Kanyisani there, you would see that it does not have blood stains. And what Captain Mangena says, he says, looking at how he bled, and one would have expected that that gun would have been at least laced with blood stains, would have been stained with blood, but it is not. Do you see that?
I see the firearm on the blood, yes.
Yes. And Mangena says he would have expected then that that blood would have been smeared with blood. That firearm would have been smeared with blood.
That's what he said, yes.
Yes. And then he also says, therefore, the way therefore it's me paraphrasing, the possibility of the firearm being placed on the crime scene after the incident cannot be ruled out. Do you see that?
I saw that, yes.
And
It starts at 15.9, yes.
Yes. And if, therefore, if a court, you would accept that if a court was to accept Mangena's conclusions, then that would spin the entire case by the Cato Mena unit that they were acting in self-defense on its head.
If a court have accepted it, but one also needs to look at the other evidence in the docket.
Yes. No, the reason I'm saying that I'm not trying to debate the merits, but it's just trying to show that, and in fact, before I forget, the evidence shows that this scene, after everything happened, Captain Eva also took over the scene. Now, if therefore Captain Eva took over the scene and doctored the scene, would you accept then that he knew, or that his colleagues, that what his colleagues had done and doctored the scene in order to make it look like his colleagues acted in self-defense?
If you had evidence to that effect, yes, then I would accept it if there was evidence.
Yes. The reason I'm asking you this because you conclude that there was no evidence of racketeering pattern. So, but I just want us to show what value did you, as the panel, attach to Mangena's statement and the conclusions, especially in coming to a conclusion that there was no evidence of a pattern of racketeering activity?
In respect of all his reports?
At least the ones that we've got, or the ones that you've analyzed, and that I've just analyzed.
Because
I analyzed 3 for a reason. Because you need 2 or more.
if there was evidence to that effect, yes.
Now,
On its own, Mangena's statement is not sufficient
can you elaborate on that?
because he talks about the possibility, and you bring it in terms of Eva coming onto the crime scene. And I said to you, if there is evidence to the effect that somebody testified to the effect that Eva would come onto the crime scene, he would clean up the crime scene or doctor the crime scene, and then you would put a firearm there, then I would accept it if there was evidence to that effect.
But do you recall where there was, I think, a girlfriend of one of the deceased who said that, in fact, when her boyfriend was shot, he did not have a firearm, but then to cover up that, they covered her with a blanket, and then they then shot the boyfriend.
Can you refer me to which matter that is?
It's in your report.
Yeah, but I need to just refresh my memory in terms of where it's been said in respect of which case. Because I do know that there are cases of girlfriends, and I think most of the statements in these cases, the family members do say that the deceased did not have firearms.
I'll just ask Advocate Mtsweni to find that for me.
While
I beg your pardon, my sisters. My sister on the right, you may.
While they are still looking for that, you said in your last answer when you were asked that after analyzing and looking at Colonel Mangena's report, do you still maintain that the police shot these victims in self-defense? Your answer was qualified. You said only if there is other evidence that corroborates. Now you are being given an example of evidence that corroborates, and you say yourself that there are other instances where family members deposed to affidavits to say the victims did not have firearms. I think the closest that one can refer to is the Biela case, where Biela Senior was shot naked. So if he had a firearm, where would he have concealed it because he didn't even have underwear on him. So there was nowhere where he can hide a firearm. And I think it's the wife, the common law wife, who deposed to an affidavit that Biela was naked and he was taken from the room by a group of police officers and then shot outside. But what happened next is there was a firearm next to his body, and then a claim that the police shot him in self-defense. Given that scenario, would you still say, reading Captain Mangena's statement and analysis, findings and conclusions, and together with the family members' statements, and also looking at the photo album, given the state of the victims, would you still say there was no evidence to show otherwise other than that it was in self-defense?
I will reiterate, my opinion will remain the same, that I will have to look at the facts of that specific case. I will have to look at other evidence in terms of witness statements, that is correct, but I've also looked at primary residue evidence. And then I will have to look at whether there were any fired cartridges from that specific firearm. So I can't now completely remember in the facts of each and every case. In this one that you mentioned, honorable panel member, but I would have to look at the whole matrix of evidence in that specific docket.
Yes, and that's the correct thing to do. But all those points that you've mentioned have been covered in Colonel Mangena's report. Whether, let's take for example, Mr. Bongani Mkhize. He found that there were no cartridges to indicate that shots were fired from inside the car. All the evidence pointed to shots being fired from outside, that is, shots being fired towards Mr. Mkhize. And then I'm not sure whether it's in this instance where he dealt with primary residue, but all those points that you mentioned, if you have gone through all these dockets and the evidence, you would have found that they were covered in the ballistic reports. And even the positioning of the firearms that are purported to belong to the victims were dealt with in detail by the ballistic and forensic analysts. Your comment?
If one refers to one specific docket, I would like to go back and read that docket and give you an indication. If Durban Central is the case that I think I remember, there was also a witness statement that was a retracted witness statement. And one also have to remember another aspect that you're going to consider as to why potentially there were no, it was a moving scene. So I would like, if you want to ask me about a specific docket, I can go to that docket and I can more or less explain. In addition to Mangena's statement, whether there were any other evidence that we considered.
I will avoid back and forth. I will just leave it at that. Thank you, Chair.
Advocate Riley, you asked me a question and say, where is that? In fact, in your statement, there was a paragraph in your report and statement, there's a chapter that deals with the planting of firearms. And in one of the cases that is referred to there, I think it's the Kwaduguza where Ms. Thandeka Sokhulu said in her statement, I will not go there, but you've summarized in your statement that at that, where I think is the death of, I think it's Lindelani Mkhize, if I'm not correct, if I'm not mistaken, who says that, it's with Lindelani Buthelezi, sorry, Lindelani Buthelezi, who says that at the time that he was dragged outside, he did not have a firearm, and then just before he was shot, they covered her with a blanket, and then she had gunshots. You deal with that at paragraph 105. Of your statement. And you criticize that, you say, well, they were not present when the shooting occurred. Now, the question I have for you is, what do you say about Ms. Sokhulu, who says, I was there, I was next to them. Just before they shot him, they covered me. Did the panel ever look at that?
That is correct, yes.
And what weight did you attach to Ms. Sokhulu's statement where she says, I saw him. He did not have a firearm, but just before they could shoot him, they covered me with a blanket, and the next thing I had firearms.
We also qualified it that when the allegations, the person were not present when the shooting occurred, and there were spent cartridges next to the deceased person, which were positively linked to the firearms found next to the deceased person. I can't remember specifically in this case, and that's why I said if we're going to go into individual cases, I will also have to look whether this is one of the cases where the deceased tested positive for gunpowder residue.
Yes.
So what I'm trying to say is that each individual case, one needs to look at the evidence in each case. So I can't generalize and say in respect of every case that is what happened.
Yes. Okay. Then so basically you concluded then as a panel that there was insufficient evidence to charge one, Major General Boysen for contravention of 21E and F, as well as the other members who were charged, because there was no evidence of a pattern of racketeering activity.
That is correct, yes.
Yes. You then move on into the next.
Before you move to the next one, you dealt with Melmoth.
Yes.
Advocate Riley, you remember Melmoth pertained to the two deceased, the Bielas.
That is correct, yes.
And in your statement, paragraph 1015, if you can go to your statement there, paragraph 101.5. You see that paragraph?
That is correct, yes.
You only make reference to Bongani Biela, only.
That is correct, but it's in the context of cases where there were warrant of arrest for persons, because I think the prosecution, Advocate Mahema, they asserted that these people were innocent, there was no reason to approach them.
I have not finished asking you a question.
Okay.
The question is 1015 makes reference only to Biela Senior.
That is correct, yes.
That case 142/11-2008, pertain to the two deceased, the two Bielas.
That is correct, yes.
And in your report, or at least in your list, you indicate that you had regard to the ballistic report of Captain Mangena. That deals also specifically with regard to the young Biela, Kanyiseni Biela.
That is correct, yes.
Where in this statement, do you make reference to Kanyisani Biela?
There's no reference to him.
Why so?
Because it's contained in our report.
Where in your report?
I will have to go through it.
Madam Chair, maybe if I might assist, I think there's reference under paragraph 102. Under case where victims were not suspects.
Yes, but in the context of the ballistic report.
Okay, I understand it.
Counsel is drawing me to paragraph 102 of your statement, where you make mention of Kanyisani Biela in your statement. But my question relates to the fact that expert findings were made by Captain Mangena about this deceased, Kanyisani Biela. My question is, did you have regard to that?
That is correct, ma'am.
Did you?
That is correct, ma'am.
Did you summarize that part of the ballistic report in your report?
I'm just trying to find that section, if I can be given an opportunity.
Yes, your report to Advocate Batoi, that is the DCOC report. If you can take me to that part, it will assist me.
There are a reference to under paragraph 194.
Is paragraph 194 saying?
That's part of our report. Do you want me to read it out, Madam Chair?
Yes.
Okay. The killing of innocent civilians, which the police allege were suspects. In the prosecution memorandum, the prosecution also alleged that the police killed innocent civilians and would then allege that they were suspects. The deceased, Kanyisani Biela and Kwazi Wiseboy Ndlovu were not suspects sought by the police. According to the accused, Biela fired at the police through a window of a rondavel when they went to arrest a family member at the reserve. The police entered the rondavel and he was fatally wounded. The cartridges found in the rondavel was positively linked to the firearm the accused alleged he fired at them. The firearm had a serial number, but no investigation was done to determine ownership.
Yeah.
In respect, yeah.
Before you go to Kwasin Glovu, did you have regard to Captain Mangena's report in relation to paragraph 194 and 195 in respect of Kanyiseni Biela? And
That is
where
correct.
does that appear in the report? In your
That is correct.
in your report, yes. In other words, the findings of Captain Mangena that were read to you earlier in relation to this deceased, Yam Biela, for example.
That is correct, ma'am.
Okay.
Advocate Riley, because I just want us to conclude on this racketeering activity before we take the lunch adjournment.
You cannot conclude when I'm waiting for an answer.
Oh, sorry, Madam Chair.
So, just assist. Would like to know and understand in relation to the Yam Biela, Kanyisani Biela, in respect of which a ballistic report had been prepared. Where does the report, the DCOC report, refers to that the ballistic findings in relation to this deceased Yam Biela, for an example?
It doesn't refer to the Mangena report.
In other words, you did not at least include the findings of Captain Mangena in relation to Kanyisani Biela that was drawn to our attention earlier in your report to assist Advocate Batoyi?
It wasn't in the report referred to. Yes, that's correct, ma'am.
Thank you. I'm not too sure, Advocate Mtsweni, this exercise, because if the witness has not summarized expert findings in relation to this deceased persons in their report, how does it assist us? Because it is clear that these expert findings in the ballistic reports were not included in the report to Advocate Batoyi. How does this exercise assist us?
Madam Chair, the only reason I was taking the witness to that was because she says that there was no evidence of a pattern of racketeering activity. Now, what I wanted to ask her is to whether, in light of what the evidence that was before them in the form of ballistic reports, which show that which cast doubt on the version by the police that they shot in self-defense, that she still maintained that there was no evidence of a pattern of racketeering activity. That's the context that I asked her. I referred her to the ballistic reports because she considered them. They considered them as the panel. And so I wanted to attach what weight was attached to those conclusions. And in light thereof, does she still maintain the conclusion that they do not establish a pattern of racketeering activity?
You can verify from her whether, in relation to the instances you have referred her to, she still maintains same.
I think I asked her that, and she said she still maintains.
She says she still maintains same.
She can confirm that. Advocate Riley, we have just spent a few minutes, quite some time, analyzing Mangena's conclusions in the reports that, as the panel, you analyzed. I'm not going to talk about other reports which Captain Mangena prepared, which also point to the same direction, but I want to focus on those that the panel looked at, which at least cast doubt on the version by the members of the Cato Manor that they had killed these people in self-defense, and asked you then that in light of at least these 3 incidents that I've referred to, do you still maintain that they do not establish a pattern of racketeering activity, or that if Captain Mangena's evidence was accepted, that would not be sufficient to at least establish a pattern of racketeering activity? Do you still maintain that view?
But
Yes, let me just conclude. I think you can give as many examples as you like.
you take the
I
individual.
think it's a matter of argument.
Captain Riley, in your affidavit, in your statement at paragraph 101.3, when you deal with Devon Central, case 185/02/2009, okay, you deal with quite a number of cases there, but you are specific on the evidence that Bongani Mkhize was one of the orchestrators of the murder of Nkosi Zondi. Are you at that paragraph?
That is correct, yes.
You sat in the panel in 2017. Were you aware that during 2008-2009, Mr. Spem Hlongo was arrested for the death of for the murder of Nkosi Zondi?
That is correct, yes. There was a case.
And are you aware that his confession was declared inadmissible as it was coerced by torture and physical we didn't want to say physical abuse, but it was coerced by torture, and therefore the judge or the magistrate ruled that his confession was inadmissible.
I don't know everything about the case, but we were aware that they were found not guilty.
So
The accused were found not guilty.
You were aware that it was ruled inadmissible?
I don't want to say that I'm aware of the facts. I just knew that the persons were found not guilty.
His case did not go to the merits. It was a trial within a trial, and the confession was ruled inadmissible.
I would accept that, if that is what you said, madam.
And then in the case of Swayo, unfortunately, Mr. Swayo was killed before he appeared, he was killed after he got bail, before his trial ran. And in his bail application, he deposed to an affidavit where he denied the confessions that implicated Bongani Mkhize, the same as the argument raised by Mr. Spem Hlongo. Are you aware of that?
I'm not aware of the bail application.
You are not aware that Mr. Swayo was, when he was killed, he was out on bail? Or you are not aware of Mr. Swayo's case?
The bail application information and that he was killed.
Oh, okay. Because here the panel says this information was later confirmed by Swayo and Spam Hlongo. And
That is correct, yes.
this sentence cannot possibly be true in line with the evidence that has been laid before us. Are you aware, or as you say, you are not aware that Mr. Swayo was on bail, so maybe you do not know?
That is correct, ma'am.
But still, in your affidavit, you say this information was later confirmed by Swayo and Spam Hlongo without having verified whether this still holds true or not.
That was, my statement is based on the information that we had at the time of making our decision or recommendations.
Which was in 2017.
2019.
2019, and this happened in 2008, 2009, long before you made your recommendations.
That is correct, ma'am.
Okay, thank you. Thank you, Chair.
Thank you.
You propose to break for lunch. It's almost 2:30. We will reconvene at 3:30. How long are you still going to take?
Madam Chair, now I can make an undertaking 30 minutes.
When we reconvene?
Yes.
We'll take a lunch break until 3:30. Advocate Riley, we're going to pause.
Yes, ma'am.
We're going to pause for lunch and reconvene at 3:30. You continue to be
Yes,
under
ma'am.
oath as we adjourn, remember?
I will do so, ma'am.
Yes, thank you. We adjourn.
Thank you.
afternoon, everyone. Good afternoon, David Chauke. Good afternoon, Advocate Riley.
Good afternoon, Madam Chair.
You continue to be under oath, Madam.
I confirm that.
Thank you.
Yes. Advocate Riley.
Proceed, sir.
Thank you, Madam Chair. Advocate Riley, can we proceed on the next chapter on your statement? That is paragraph 91 all the way to 95.
It is correct. I'm here.
Yes, you tell us that as the panel, you had identified that at least 9 accused were charged with racketeering despite the fact that they were only involved in one incident. And you cite the case, the cases wherein they were involved.
Before you answer, are the air conditioning, are they working? It feels hot, or am I the only one?
It's hot.
Is it hot? May we get help, please? Is it working? Would you please check this one on the right side? Yeah, how does it feel, madam? It's hot. Please try to control both, even the one on the center. Thank you.
May I
Thank
continue?
you. Yeah, you may proceed, sir. You can remind the witness of the question.
Yes, Advocate Riley, I will just ask you a question that you, in your statement, you list a number of persons who were charged for racketeering despite the fact that they were only involved in what you term one incident.
Can I just want to have a look at this section. Yes, just 12, yes, they were charged with one offense in the predicate offenses.
Yes.
And I list the incidents.
So are you saying they were charged with one offense or they were charged for multiple offenses under one incident?
They were charged in one incident, similar to the Howick matter, where we said one incident, and then it could be multiple offenses in one incident.
Yes. And you then basically, on the basis that they were charged under one, they were charged with racketeering despite being involved in one incident, they were wrongly charged.
That is correct, yes.
Yes. But despite that, in your recommendations, if I might just, you do not ask that or recommend that the racketeering charges or certificates, to the extent that they relate to these accused, should be withdrawn. You in fact recommend that the entire both authorizations and the charges against the entire people who were accused who were charged with racketeering be withdrawn. Now the question I have is, does the fact that a person who is charged with racketeering or not to have been charged with racketeering, does it invalidate the poker authorizations?
Person was not being charged.
Yes.
I'm just trying to understand what you're saying, Advocate Mtsweni. Can you repeat your question?
I'm saying that despite you finding that these accused were wrongly charged under poker, you nonetheless in your recommendations recommend that the poker authorizations and the racketeering charges be withdrawn against everyone. Is that correct?
That is correct, yes.
Now the question is, does the fact that a person, one accused amongst the group of accused who's been charged with racketeering, does the fact that the accused was wrongly charged, does that invalidate the entire proceedings?
In respect of, we've gone through the Cato Manor grouping, we've gone through some of the accused that were charged in one incident. That is correct.
Yes. Thank you. And then, in the next paragraph.
Sorry, is the witness saying it is correct that once you find that there are few people who are wrongly charged, then it invalidates everything? Is it what the accused? Sorry. Is it what the witness is acceding to?
No, ma'am.
I didn't want to mishear or misunderstand her.
Can you just clarify that, Advocate Riley?
I did not say that if there are people on a racketeering indictment is charged wrongly, in other words, that they don't belong as part of that racketeering, that invalidates the whole authorizations. That is not what when I said that. It does not imply that.
Okay. Thank you. Are there questions from the panel, Madam Chair? Yes. Now, then, you then criticize from paragraph 96 the reliance on the monetary awards as being the purpose or the basis of finding that there was an enterprise.
That is correct.
And you say, first and foremost, there were two streams of payments which were identified. Firstly, by the Stenga. Secondly, the monetary awards by SAPS.
That is correct, yes.
And then you say that there was no evidence insofar as the Stenga payment stream that showed that there were payments made to Major General Boysens, and no, that there was evidence that the money was dissipated to the members of the Cato Manor squad.
That is correct, yes.
But in doing so, did you have regard to what at least Matonsi said? Is it Matonsi? Who said that he was present when the money was given to Boysen and Mostert? Did you have regard to that?
Firstly, I don't recall whether he said it was given to Boyson, and he said it was given to Mostert and an unknown man. And yes, we have debated at length now the why we said we did not place any reliance on the Matonzi statement. So we did take that into consideration.
Can I ask one quick question? Did you have any evidence to the contrary, especially where you say there is no evidence that shows that the money given to Boyson, and we know that we have a witness who said, I was with so-and-so who went into a car where there was Boyson and Mostert. He had a large envelope and the envelope had money, he gave it to them. Did you at any stage during your analysis find contrary evidence that would have convinced you that either the money was not given to Boyson or to Mostert, or there was no money at all, or any other evidence that would help you come to this conclusion?
There was no evidence in the docket. If that was properly investigated, one would have expected, and that's one of the points that we raised in our report as well. There was no financial investigation done. So one would have expected a financial investigation to be done, as well as an asset forfeiture investigation to potentially show that besides the money that they receive as a salary, they through their assets, through a bigger house, holidays they've gone to, as well as monies in their banks, that they have more money than would have been expected from a police officer on a salary. So that would have, but there was no such evidence.
And all that while we are still at the stage of seeking authorization certificates, not at trial stage.
The requirements are for a racketeering authorization is that you do a financial investigation, potentially to show money laundering, and then secondly, you do an asset forfeiture. That is standard in terms of any racketeering request for racketeering authorization. So one would have expected that to have been part of that investigation, even at the stage when they submitted an application for authorization to the NDPP.
You say that it is standard.
That is correct.
Can you direct us?
I will have to go to
relevant provisions of the Act, maybe?
There's no provisions in the Act. It's internal in terms of what is required in terms of a poker prosecutions. Obviously, in terms of a poker prosecution, we say that the drive in order to commit these offenses is very often, or if not in the majority of the cases, it's financial. It's the financial benefits that you're trying to obtain. So part of our requirements in terms of our policies is that when you look at a criminal network, in particular criminal network that is committing crimes, that you have to look at the financial investigation and that you have to look at asset forfeiture.
Is it standard?
It's not in terms of any law.
Oh, I'm sorry. I thought you were done. Sorry.
I said it's not in terms of law. It's what is required of a prosecutor when you conduct a prosecution, a racketeering prosecution.
My next question would be, is it standard or does it differ on a case by case? Are all cases where you deal with poker and racketeering the same, or you deal with them on a case by case basis?
You are required, when you do an application for racketeering authorization, you are required to address the NDPP whether there was any financial investigation and whether there was an asset forfeiture investigation. And both those, that forms part of our discussions around whether racketeering should be authorized or not. You are required to address the NDPP on the financial investigation as well as the asset forfeiture investigation. So I wouldn't say it is, I think that's the norm. That is what is required. Even if you don't find financial benefit or asset forfeiture benefit, you still have to address the NDPP on that.
Thank you.
Advocate Riley, if I may just ask, the standard for institution of criminal proceedings is prima facie case, am I correct?
Prima facie case, yes.
Now, what is the standard for to be applied by the DPP, by the NDPP, when he or she decides to issue poker authorizations? Is the standard the same?
That is correct. I think you still have to consider reasonable prospects of success, even if there's a prima facie case.
So prima facie case means that there's a case to answer.
That is correct.
So the test is the same throughout, in both instances.
I think our policy manual referred to prosecutors in general. What is your role, as well as what do you have to consider when you decide to institute prosecutions or not?
Please
and
just
also
answer,
factors to be considered.
Counsel Advocate Riley, confine yourself to the question by counsel, by Advocate Mtsweni. Please repeat that question.
I'm saying that the test is the same for both institution of criminal prosecution as well as granting of poker authorizations.
Yes, you have to, you're a prosecutor, you make a prosecutorial decision.
Yes, and there's still room that even after the issuance of poker authorizations or institution of criminal prosecution, that that investigation can still be done, mostly under the direction of the prosecutor.
Yes, that's correct.
So basically,
investigations continues.
Yes. So basically, it is still open to a prosecutor to ask that certain information that may not have been there when the decision was taken, that information be obtained.
Yes, you can ask if you didn't have it, yes.
Yes, and that would not invalidate the prosecution.